Good morning, everyone. Apologies from ICJ Kenya for starting this webinar a bit late, but thank you for finding time to be with us. And welcome to one of our BBI informative sessions. Last week, we had a broad-based conversation on the general BBI report and the recommendations contained therein. Today, we want to take a specific focus on Chapter 10, which is the chapter that focuses on the judiciary. Again, thank you for finding time to be with us. My name is Julie Wayomadheka. I am pleased to be co-moderating this session with Elsie Saina. Now, over to you, Elsie, for a bit of context on why we're here today.
Thank you, Julie, and good morning, our panelists. Good morning, our participants. We are so delighted to be with you again this morning, and we will explain to you why we are having this webinar again, following, as Julie said, last week we began on a broad-based conversation, but specifically we are coming today to talk about Chapter 10, on the Constitution that speaks to the judiciary. And this dates back again to 2018, amidst the calls to lower the political temperatures amongst the divergent functions. His Excellency, the President Uhuru Kenyatta, and Right Honorable Raila Odinga met and agreed to work together. The partnership symbolized by a handshake and which represented the end of political and election tussle, but what we now call the BBI initiative process that was spearheaded by both Uhuru Kenyatta and Raila Odinga in order to build a nation, to discuss, build consensus towards unifying Kenya. From our observations as jurists and based on our discussions last week, there are those who agree with the report, there are those who disagree with the report, and there are those who agree with some parts of the report, calling for dialogue on the issues that are contained. The BBI proposes a raft of recommendations, and to focus today on judiciary, have overarching and broad recommendations. The underlying rationale is that the proposals are intended to give direction of enhancing judicial accountability for the people of Kenya. Broadly, the BBI states that while the independence of the judiciary must be respected and protected as a fundamental principle, the judiciary should equally be accountable in a transparent manner to the sovereign will of the people of Kenya. It is for this reason we have convened again today's webinar, so that we can all interrogate the divergent perspectives on this chapter and a raft of recommendations regarding the judiciary. Allow me now to invite my co-moderator, Julie, to introduce our very distinguished and able panelists. Over to you, Julie.
All right, thank you very much, Elsie. Now, to engage us in this discussion and unpack the recommendations is a panel of distinguished jurists and legal practitioners who have immense understanding on the subject matter. Allow me to introduce them to you briefly. First off, we have Honorable former Lady Justice, Dr. Nancy Baraza. She is a lecturer at the Department of Public Law in the University of Nairobi School of Law. She is an advocate of the High Court of Kenya, and she was the first Deputy Chief Justice and Vice President of the Supreme Court of Kenya under this current constitution. She has also served as a commissioner with the Constitution of Kenya Review Commission, CKRC. Thank you very much, Daktari, for finding time to be with us. We have with us Honorable Mutula Kilonzo Jr. Honorable Mutula Kilonzo is with us. We have with us Mr. Elisha Ongoya, who is an advocate of the High Court of Kenya and a partner at Wambola and Ongoya Advocates. He was the Dean of the School of Law in Kabarak University and is now a senior lecturer with the institution. Our last, but certainly not least, the panelist who has joined us today is Ms. Christine Konge, who is the Executive Director at the Katiba Institute. She's an advocate of the High Court of Kenya with diverse experience, including on criminal justice, gender-based violence, and children's rights. Thank you very much to all our panelists for finding time to be with us today. Now, to our participants, please stay tuned as we tackle these pertinent questions on BBI and specifically on the judiciary. We invite you to engage the the panelists in our Q&A section. Leave us your comments, your questions, raise your hands if you would like to call in during our plenary session. Please keep us engaged in our social media platforms, on Twitter at ICJ Kenya, and on Facebook at the Kenyan section.icj. And I'm sure you will follow all our respective panelists on Twitter as well as they engage us on this discussion. Now, we want to kickstart the conversation, and I will now hand over to my co-moderator, Elsie, to begin.
Thank you very much, Julie. Allow me to begin with a general question to our panelists, and thank you for that introduction, Julie. And to our panelists, the first question I'd like to pose to you is that the BBI proposes the introduction of Article 172A to the Constitution, creating the office of the Judicial Ombudsman. The person, as is conceived, shall A, receive and conduct inquiries into complaints against judges, registrars, magistrates, and other judicial officers, including judicial staff of the judiciary. B, the ombudsman will be required to sensitize and promote engagement to the public on the role and performance of the judiciary. And C, improve transparency and accountability of the judiciary. What are your thoughts around the creation of this office? With no specific order, please allow me to start with Christine, then followed by Honorable Mutula, thereafter Honorable Dr. Baraza, and then last but obviously not least is Mwalimu Ongoya. Over to you, Christine. Welcome.
Thank you so much, Elsie, and for that interesting question on this new office that is supposed to be set up and be part of the Judicial Service Commission. So we all know that the history of the Judiciary Ombudsperson. This was an administrative office that was set up by the former Chief Justice, Willy Mutunga. So it was an office set up under the Office of the Chief Justice as an administrative office, and it was, the officer who was sat in that office was given delegated powers by the Chief Justice, mainly to assist him with certain functions that are delegated to the Chief Justice under the Judicial Service Act. So there are certain disciplinary powers that are delegated to the Chief Justice, and that is the role now that the DCJ currently plays as a judiciary ombudsperson. So this was an office that was squarely under the control of the judiciary. So now and again, this ombudsperson was carrying out preliminary or initial investigations to assist the CJ in effecting its disciplinary role over judicial officers, magistrates, and other judicial officers. So you also had, as you indicated when you started Elsie, the power to, the obligation to assist in creating positive publicity for the judiciary and being, the PR person under the Chief Justice's docket to assist with public affairs in relation to the Chief Justice's office. So now, this is now supposed to be set up as a constitutional office, and more so, and of interest to us as people who are interested in the independence of the judiciary, is the fact that this will be a person that will be appointed by the president and approved by the National Assembly. So again, does that increase the independence of the judiciary, or does that increase executive inroads into the independence of the judiciary? Why I say the independence of the judiciary is, of course, the Judicial Service Commission is supposed to enhance the independence and accountability and transparency of the judiciary. So any interference with the independence of the Judicial Service Commission has a bearing on the independence of the judiciary. So the question is, what's the problem that is supposed to be cured by this new addition to the Constitution? Why must it be a constitutional amendment and not something that can be brought about by legislative enactments? Why do we need to include something that was started off as something to assist in complex mechanisms under the Chief Justice's office? Why now does it need to be included in the Constitution? What's the evidence? Again, just with as with the BBI process in general, we don't know what is that need that they have ascertained that necessitates the inclusion of this person as a Judicial Service Commission member. And more so, why is this person not being appointed through the judiciary, but is coming in as executive appointee. So now we have the people who come in through executive appointees being four. We'll have the Attorney General, who's a permanent member of the Judicial Service Commission. We have the two members of the public that are supposed to represent the public interest who are appointed by the president. And now we will have this other person coming in, appointed by the president, again, for I do not know what purpose, is carrying out the role that is actually being given to the judiciary, to the JSC as a whole, as a collegiate body. So that role is being given to him. We don't understand why that is not a role that cannot be carried out under the Secretariat of the JSC, and why that needs to become a constitutional office. So it doesn't make sense to me at the moment. I would need to see more evidence of why this is necessary. It is not a necessary constitutional amendment. It has been working well as it has been, fully and wholly under the control of the judiciary. Now that independence is being interfered with. That's what I'll say, Elsie, for the time being.
Thank you very much, Christine. Yes, over to you, Honorable Mutula. Your thoughts on that broad question?
First, let me disclose that I have been privileged to act for two judges together with my late father in the Ringera, so-called Ringera radical surgery. And it came to pass that, and I'm now speaking broadly before I get into the detail, that prior to, in fact, that small committee that was headed by Justice Ringera, previous Chief Justices have had what would be ad hoc methods of handling complaints against judges. And I think, to his credit, Chief Justice Mutunga then set up this as an office under him, because previously, prior to Justice Mutunga holding office, this was handled directly by the Chief Justice. So they had the opportunity either to deal with the issue or tell the judges that we have complaints against you, but it was all done in a manner which the public then wouldn't come to find out, because they were attempting, of course, to protect the integrity of the judges. But it has come to pass that more and more that we need the judiciary being as open as possible, and complaints against judges must be handled in such a manner that then you don't end up with the Ringera issue, the Ringera radical surgery, or then led by Kiraitu Murungi then as Justice Minister, and at the same time protect the judges. Under the current framework, the DCJ is delegated by the Chief Justice to be the ombudsperson. It leaves a lot of questions that, of course, we must address as a country. One is whether, in fact, if there's a complaint against the Chief Justice, whether the Deputy Chief Justice can handle that complaint. If there's a complaint against any other judge, whether that judge can handle that complaint. And I have this in mind because I did some research for my late father and I have some history. In the Supreme Court Act, there is a provision under Section 14 that was supposed to interrogate the judgments that were done prior to the Ringera Committee, and a review then set for the Supreme Court to interrogate judgments that were done by judges who were either removed or who admitted that they had committed certain offenses in handling of their matters. And the Supreme Court has issued a ruling to suggest that, or finding that they have no jurisdiction and it's unconstitutional. So you're left with a gap where judges are supposed to investigate themselves. They appear not to be able to investigate themselves, and yet the public are complaining that there are issues. I was in an election petition just the other day, 2017, and the judge actually mentioned in a court proceeding that nobody should go to his chamber. I was in an election petition, one of an MCA, where the magistrate said nobody should attempt to call him or attempt to influence him. So first, let's admit that there's a problem, that there are litigants and interested parties who are attempting to influence court cases and judgments. I have an instance where a person who I shall not name approached me after an election petition I did in 2007, a very senior person who told me, next time, Senator Mutula, you're not going to be lucky. I was not a senator at the time. Thirdly, in terms of an office of judicial ombudsman, I am aware, and it's fair that I disclose to this very good group, that a presentation was made, a very serious presentation was made on the reason why we should have an ombudsperson. The jurisprudence, and it has happened in Malta, is in the UK. So the fact that we have bad drafting in this document does not mean that we do not need an ombudsperson who is not necessarily a judge, who can listen into cases. But let me admit that this document, the way it is drafted, has raised questions, because there's no reason why an ombudsman should report to Parliament, an ombudsman should report again to the president. Why should that happen? Two, if you read the clause itself, the better option would be to have an ombudsperson who is an ex-officio member. That's one. Two, you see no linkage between a complaint against a magistrate and a judge vis-a-vis the removal of a judge and the process of removal of a judge under the Constitution, which is a problem. But let's admit that for purposes of ensuring that we can deal with judges as individuals, and that is not condemnation of the good judges who are doing a good job, but in every other case you find a person who is rogue. How do you deal with that person, and how do you deal with that case? To the extent, therefore, first of all, you protect the integrity of the court, the independence of the judiciary, but at the same time you handle that rogue person and remove them from office if there's evidence that that person has committed an offense. My view is that this provision is badly drafted, but is necessary for purposes of ensuring that 20, 30 years from now, you're not talking about a Chief Justice like Maraga who was able to nullify a presidential petition. You're talking about another Chief Justice. Will that Chief Justice or another court be able to annul a presidential election without receiving telephone calls? In the case of this court where they have to switch off their phones and go and hide. Why were they hiding? Thank you.
Very much, Senator. Indeed, you've posed that there is really a problem, and how do we address it? And at this juncture, allow me to bring in Dr. Baraza also to give her views and insights on the questions we had posed on the establishment of the Office of the Judiciary Ombudsman. Over to you, Judge. Thank you. If you could unmute, then we can hear you.
Unmute, all right.
Thank you, Judge.
I think I want to agree with Senator Mutula that the drafting around this matter in the BBI is very, very sloppy, and that is probably where the problem is coming from. There is no doubt that the judiciary needs a judiciary ombudsman. And I was privileged to have been serving with Honorable Chief Justice Mutunga when we created that office of the Ombudsman. And the reason was the Chief Justice's office was so inundated with complaints. Mine was so inundated with complaints. On a daily basis, you would receive like 100. And so to be able to handle those complaints, then we did agree with the former Chief Justice that we create that office of Ombudsman, of course, speaking from best practice from countries like Malta, from Britain. They have ombudsmen, but basically administrative people within the judiciary itself. And his function was, of course, to receive complaints from private citizens about the judiciary, about the judicial officers, you know, all manner. And we were just so flooded. And that is how we came up with that office, but it is also grounded in good practice. Now, when we created that office, then we put in a young magistrate called Bidali. I think he was a chief magistrate or something, to be the one to receive those complaints and sift them and place them where they needed to be placed. And he was a magistrate. He did that the best that he could. But there were also complaints about judges, which were going to Mr. Bidali, who was a magistrate. And of course, a complaint was raised that how can a magistrate be dealing with issues of a judge? And that is how that job of Bidali was moved to the DCJ's office, because I think, not during my time, I think during the current time, because it was deemed that office was not too busy, all right? So it could sort out those issues. But basically, the envisaged ombudsman is a judiciary administrative person. Now, so I have no problem with the creation of a judiciary ombudsman who emanates from the judiciary itself. But the way it has been drafted is extremely sloppy. We can have a judiciary ombudsman separate from the DCJ. That one is very necessary, because really that should be a separate and administrative person. It can't be the business of the DCJ to go sifting through complaints. However, in my view, the appointment of that ombudsman through the process, which seems to be solely for executive and parliament, will certainly interfere with the independence of the judiciary. Such an appointee, in my view, will be susceptible to control and direction by the executive and by parliament, or it may be so suspected. And you see, perceptions also matter. So the bringing in of executive and parliament is a bit problematic. I have no problem with such an administrative person being at the level of a judge and appointed through the same process that we appoint judges, where the president appoints, like he appoints judges, okay? I wouldn't have a problem with that, but let it be a judiciary person. The initiative is from the judiciary, and he's not subjected to executive maneuvers, because then that will defeat the intention of Article 160, which states that the judiciaries shall not be subjected to the control or direction of others, including executive and parliament. As to independence and accountability of the judiciary ombudsman, he really, if we conceptualize this office well, then it can serve to do administrative work of the judiciary, and therefore smoothen that part of the function of the judiciary. But he should not sit in the JSC. He cannot. This is an administrative office, which will sift through complaints as one of its jobs. And some of those complaints touch on judges, and so he can pass them over to the judiciary, to the Judicial Service Commission. So he can't sit in that Judicial Service Commission. He sits separately and deals with administrative things and places the complaints where they need to go. And then I think where I have another problem is the creation of that office as an independent office of the Constitution. Because then you are creating a constitutional office, which is like the JSC, which is like the Commission on Administrative Justice, that's another ombudsman. And then most of the things he deals with, it means he will be reporting to the JSC, and he's an equal constitutional office. He will be reporting to the Commission on Administrative Justice. He's an equal to that commission. So there would be some incongruence there. It doesn't make good sense. But the office is necessary. Let them rationalize it. It doesn't have to be constitutional. Or if it is constitutional, let it be rationalized. Let it not be seen as an extension of the executive. I think those would be my views.
Thank you very much, Judge. Allow me to invite Mr. Elisha Ongoya to also share his perspective and views on the proposed office of the Judiciary Ombudsman.
Thank you. Thank you so much, International Commission of Jurists, for this opportunity. And more significantly for me, for giving us a chance to debate on relevant issues affecting our society. Because if we don't debate, then we are as good as a dead society. Having said that, allow me to say this: for as long as we run a system of governance that is managed by men and women, there will always be a problem here and a problem there, which we must constantly seek to address. That's critical for me. But number two, and this is where I agree with Madam Christine Koge, it is to ask, what is the nature of the problem we are dealing with? And number three, to ask, is it possible to use existing mechanisms and existing institutions to deal with that problem? Because my fear about recommending new laws and new institutions for every perceived new problem is that far from solving the problem, it culminates into what I have described elsewhere as legislative inflation or institutional inflation, where you have so many laws and so many institutions overlapping on the same subject matter that the net effect is more confusion rather than order. I have tried to study the phenomenon of judicial independence, and in particular, when I look at the question of the Judicial Ombudsman as proposed in the BBI report, it is to deal with elements of indiscipline in judicial office, indiscipline among judicial officers. That is the aspect of the problem that institution is designed to deal with. And there are two broad categories of problems of indiscipline, what one may call minor problems and great problems, grave problems, gross indiscipline as is described in the Constitution. Now, society has a mechanism of dealing with each of these problems. The most efficacious way of dealing with minor problems of inefficiency, minor problems of indiscipline, minor challenges within judicial staff is through peer review, through getting judicial officers constantly interact and look at each other in the eye and say, good people, where are we getting it wrong in terms of enhancing the efficiency of this problem? That does not require external interference. That requires peer review. And you can see this through possibly what you call annual conferences, through judicial training, where you bring judges from the hallowed office of judge or magistrates and sit them in a hotel room, in a school, in an informal environment, and they debate these day-to-day efficiency questions, and they come back slightly better people. I have been privileged to train judges through the instrument of the Judicial Training Institute, and many at the times I've had people confessing that, you know, had I had this version of logic before I handled that other matter, I would have done it differently. This is how people make themselves better. Then secondly, of course, there is externally through what I call criticism, public criticism and academic criticism, where the public is allowed to express displeasure through academic discourse. And we're talking about dispassionate pleasure here. You don't go for personalized attacks on judges, but for example, you study the jurisprudence and analyze the jurisprudence in academic journals, in academic forums, and so forth, so that judicial officers are bound to be much more careful when they draft the next advisory opinion, the next judgment, knowing that it's not going to end there. It's going to be a subject of rigorous academic interrogation, and no one wants to be adjudged to be intellectually or jurisprudentially a lightweight. They will do their best, not to generate perfect judgments or perfect decisions, but to generate fairly well-reasoned decisions that are not a subject of dismissal by a wave of the hand by a first-year law student. Then the third category is now gross misbehavior, where judicial officers are behaving very badly, which now we deal with through punishment. There is an existing mechanism at the moment where you file a complaint before the Judicial Service Commission. The Judicial Service Commission investigates the complaint, and where it is gross, for purposes of lower cadre judicial officers, by which I mean magistrates and members of tribunals, administrative tribunals, they can simply be dismissed or punished as known to the Judicial Service Act. For purposes of superior court judges, there's then a recommendation for an appointment of a tribunal. What I want to be guided on by those who recommend another institution is the question, what is so inefficacious about this mechanism as to necessitate establishment of another institution superimposed on the existing institution to be able to deal with it effectively? I think, speaking for myself, that the existing administrative mechanisms which the office of the Chief Justice and Deputy Chief Justice were dealing with by way of a judicial ombudsman established administratively within the judiciary, where necessary, when they receive complaints, to call on judicial officers to explain themselves and return feedback to consumers of the justice sector, is an effective mechanism. There is need for justification for establishment of another constitutional office to be able to deal with that. As I sit here and as I make my comment on this, I do not see the need for establishment of another judicial office, worse off, established or proposed to be established in a manner to show overarching executive intrusion in the judiciary. That only adds insult to injury. And those are my thoughts.
All right, thank you very much to our panelists for kickstarting the discussion and setting the pace for the discussion that you're going to have today by giving us those insights on the Judiciary Ombudsman, the creation of the office, the processes, the reporting structure, and basically underscoring the fact that we do not need to do legislative inflation. I like that, and I'll definitely be using it in the course of my drafting going forward. Now, I want to start with specific questions to each of you panelists, and I'll start with Christine. And my question to you, Christine, is, and which has already been discussed, is, should the Judiciary Ombudsman be a member of the JSC? Do you agree with the sentiments already raised by some of your co-panelists? And the next question is, and as you have seen, the BBI has proposed the enhancement of the qualifications of the judges of the Supreme Court and judges of the Court of Appeal. You can kindly highlight what are your thoughts around both of these issues that the BBI has presented. Over to you, Christine.
Thank you, Julie. Okay, I do agree with all the sentiments that have been given by my fellow panelists on the issue of the Judiciary Ombudsperson being a member of the JSC. Yeah, so, and as Honorable Dr. Nancy Baraza has indicated, it is also the creation of that Ombudsperson's office was created also under the spirit of Section 8 of the Commission on Administrative Justice Act that calls upon all public institutions and state offices to create internal public grievance mechanisms. So I don't know why the JSC or the judiciary is the only institution that is being flagged out in relation to the ombudsperson's offices that are being created there. That will definitely gives an indicator of executive overreach into this into the judiciary, and that should be of concern to us. So as I agree, as they have stated, it should be an administrative office coming from the judiciary itself. There's no need for it to for this person now to become a member of the GSC. If this is a person who's also going to be handling the investigative phases of complaints, then also go to the JSC to become a judge and prosecutor in the same causes that he is investigating. There's really no need for that. This is something that can be handled, as Ongoya said, in the current mechanism. If there's anything that needs to be beefed up, it can be beefed up under the current mechanism. There's no need for a constitutional amendment on the same. Now, Julie, the second question was on the age.
Yes.
The age of for an applicant to be able to become the Chief Justice of the Republic of Kenya, they have increased. The BBI proposes an increase of age from 15 years of service to 20 years, and that of the judge of a court of appeal from 10 years to 15 years. Whereas I do not necessarily see a very, a big problem with that, it's also not something that is steeped in reality. I mean, people have applied for these positions, and whereas people who have junior experience have applied for in less than 20 years, that is, have applied for this position, most often, always, the position has gone to people with actually a lot of experience. So it's a situation that is captured with the realities of the recruitment processes. So we end up having judges who have quite a lot of years of experience. So I don't, maybe the rationale is that we need a little bit more wisdom on the basis for saying that. I'm not sure what that is, that has made it seem that 20 years and 15 years give a lot of difference. So I really don't see quite a lot of objection on this, except it's just random number, just like 15 years was a random number. So again, this is, as I've said, the processes, the recruitments as they happen actually always mean that people that end up being successful for the positions have actually a lot of years of experience, 20 and above.
All right. Thank you, Christine, for those insights. And indeed, it begs the question, what are we amending to, what are we trying to amend rather with the increase of the number? So it's interesting discussion that you're going to be having, and hopefully a few of our other panelists will also shed a bit of light about what they do think is a rationale behind the increase of the requisite number of experience for persons who are applying to these positions. I'll now hand over back to Elsie for more questions to our panelists.
Yeah, thank you very much, Julie. And allow me to bring back Honorable Senator Mutula, just to go back to the comments you made earlier. Indeed, you've actually alluded to the fact that there is a problem. There is a problem of discipline. There's a problem of misconduct amongst judicial officers, including your own practical experiences in handling election petitions, or even during, the Ringera process of, the radical surgery of the judiciary. So back to the question again of the Judiciary Ombudsman, specifically pointing to the fact that the BBI appointment process of the Ombudsman has indeed provoked, as you rightly put it, debate, with some still arguing that it is yet another attempt by the executive to undermine the principle of separation of powers, while others argue that it is indeed necessary. And we've heard from the Honorable Judge that yes, at the time that she was serving, it was conceived an administrative role to handle the many complaints, the voluminous complaints that they received at the judiciary. So my quick question to you is, Senator, is the Office of the Judicial Ombudsman the key to enhancing judicial accountability, broadly speaking? And secondly, does the appointment of the Ombudsman by the President go against the separation of powers principle? Over to you, Senator. Thank you.
Thank you. The first question as to the necessity of having judicial, let me start with the second question. The second question about, I said, I must confess that the people who did this drafting did it wrongly, because in an attempt to justify a mischief, they went about it the wrong way, to the extent therefore that to then mention the head of state as the nominating authority, as opposed to performing a function like the one of appointing a judge and appointing a chief justice or a deputy chief justice, which is a formality. They begin with the nomination. Now, my experience, and I must say this, and because I was trained well by Nancy Baraza and others, is that the road to hell is paved with good intentions. The fact is that although it appears very innocuous to have the president nominate and then the approval goes to the National Assembly, and unless there, I mean, in the history of Parliament that have been there, other than the one of Mwinzi, ambassador, Parliament has not rejected any appointment. They approve so quickly, so fast, that I doubt that we can have a good mechanism of a parliamentary procedure. Parliament does not reach a stage where it disagrees with the president on a matter as fundamental as this one. So to that extent, there's the discomfort by Kenyans is real. That would be ideally the president is the president, whether current or any other. And we might even get people are thinking about the current president who is about to leave office. We might get a president who is a dictator and who will impose his will on everything. So the caution that should be there in such things is that we should limit the role of the executive. Even though I agree with the process of vetting, which happens all over the world. I mean, we witnessed the vetting of the processes of the Supreme Court judges in the US. Although even then it's done by the president. You can see some element of tackling the issues properly. Is it necessary? It is necessary. It is the way to handle it. We will not agree, all of us, but let's agree about the country called Kenya. The country called Kenya, unlike other developed ones, has got trust deficiency on everything. It's got trust deficiency on the church. I remember sitting in a panel to appoint the current IBC commissioners. And the only way we thought that at that time that we would get good commissioners of IBC, we put the church. We ended up with Chebukati, Chiloba, and everybody else. Now, so parliament is monitored by somebody. The judiciary needs to be monitored by somebody. The president needs to be monitored by somebody. We have a trust deficiency in this country. I agree with my good friend Ongoya. I mean, from an idealistic perspective, we have laws on everything in Kenya, but we have problems on everything in Kenya where we have laws on everything. That we must agree. That we are a society where we have to legislate on every simple little thing. That we don't trust ourselves to do something without legislation. That we are arguing between the Speaker of the Senate and the Speaker of the National Assembly and Article 110.3 whether they should sit or not sit. They don't sit. Now I've drafted legislation with Senator Sakaja because the drafters of this constitution, and I must thank them, some of them thought that we are the country of good men and good women. Let's operate on trust. And therefore, some of the things that you are seeing are because that is where our country is. We want everything in the constitution. National Assembly members want CDF in the constitution. World Development Fund in the constitution. We're going to have everything in the constitution. Why? Because we have trust issues. And so since it's a society where we have lived that way, I strongly believe that this, I think, is one way. I wish we could follow the peer review. And I want to inform my good friend Elisha that we had peer review mechanism under previous chief justices. It was there. Has it worked? No. Have the complaints increased? Yes. And you must thank Chief Justice Willie Mutunga and Nancy Baraza for coming up with something so innovative, although it was very quiet. Nobody used to know that this was happening. And there was never public reports about how this is functioning. I still think that it's a way of getting things done. If you go to other countries where they have put mechanisms, policing mechanisms, the fact that somebody is being policed, if you go to China, you find there are cameras all over the place. Nobody is stealing, but the fact that there's a camera somewhere, nobody will steal. So it's possible that this judicial ombudsman in some point in 10 years will be so idle. There will be nothing for him or her to do because all of us will have reformed. and then it will not be necessary to have it in the constitution. But ideally, it should be done administratively. The way they do it in the UK is done administratively. The Queen, the Majesty appoints. The Lord Chancellor was the head of the judiciary in England. I mean, there was no issue. But I mean, can you imagine a place where the Attorney General is the head of the judiciary in Kenya? It will be an atrocity. Thank you.
Thank you very much, Senator. Wow, indeed, as you've really underscored the fact that our endemic problem is a question of trust deficiencies, both in our institutional, in our value system, but also possibly informs why everything we want to do in Kenya is to legislate. Thank you very much for those insights, and also praising the fact that, the peer review mechanism is likely to, could have been an innovative mechanism that could potentially support the accountability question that we are consistently asking and asking as members of the public, and how do we hold our judiciary accountable? What mechanisms can we, that are not necessarily legislative, that can we utilized to ensure there's accountability. Allow me to draw in Dr. Baraza for her specific questions. Judge, we have a question for you that, what is the impact of enhancing the Judicial Service Commission's mandate to include disciplining judicial officers, including judges? So that's the first one, and away from the conversations about the Ombudsman. And a further proposal contained in the BBI that proposes that the election petitions, other than that of the presidential petitions, ought to be declared closed once they are at the Court of Appeal and the Court of Appeal has given judgment. Could you please, Judge, elaborate a bit more on these proposals and the rationale for members of the public and our jurists sort of to understand and interrogate? Welcome, Judge.
Thank you very much. And before I go there, let me just compliment what Honorable said. I think we keep throwing laws at everything. And once we put a law in place, we think we are sorted out. Everything has to do with our values. Everything has to do with the utilization of the institutions that we have. But we have that tendency of throwing law at everything. But just to go to the proposals of BBI on enhancing the power of the JSC to discipline judges, I think that would be going contrary to practice around. I think around the world, the judges are elected people. And so to discipline, I think just them at JSC, that would be a bit, it's not done elsewhere. It's the problem now. Judges are elevated people. They are tribunal, and it works around the world. I'm hesitant to, I don't know if that's what they mean, but I'm hesitant to support that proposal that we leave JSC to discipline judges. It is discipline for purposes of gross misconduct, for removal, that should go beyond the JSC. And I don't see what is with the current mechanism of the appointment of a tribunal. All right. Now, the question was, which one was it?
Was the question on the election petitions, the final judgment of the Court of Appeal, other than the presidential election petitions?
Absolutely. If you go to our constitution tree and go to the drafts, the original draft envisaged a very, very vetted Supreme Court, extremely vetted, so that it deals with very, very serious and unusual issues, and so removed appeals from petitions to the Supreme Court, and it was actually meant to deal only with presidential elections. So the enhancing of the duty of the Supreme Court to handle appeals on ordinary election petitions was a question of the courts themselves. Some people argued that probably the Supreme Court was idle, they needed work to do. But the philosophy behind it was that those petitions would end not at the Supreme Court. The only petition would be the presidential petition. So I think that proposal would be recapturing the philosophy that there was initially.
Thank you very much, Judge. Allow me now to invite Julie to ask the next panelist our questions. Thank you, Julie.
All right, thank you, Elsie. And thank you to Honorable Judge, Senator and Christine for your insights on the topic. I want to quickly remind our participants that they can engage us in the chat section. And if you wish to voice your question to the panelists that we have, please do indicate by raising your hand, and the technical team will get in touch with you so that we can prepare you for the question and answer session. Now, I want to turn to Mr. Ongoya. Now, the BBI proposes two things that are very drastic. And the first one is The LSK representative to the Judicial Service Commission should not practice before the courts and tribunals while serving as a commissioner. And the second thing is the BBI proposes the harmonization of the tenure of the Deputy Chief Justice with that of the Chief Justice. I'd like to get your quick thoughts on these two recommendations that the BBI has presented. Over to you, Mr. Ongoya.
Thank you so much. There are two aspects I want to deal with distinctly, although they are related. One is identification of the mischief, and two, the appropriate method of dealing with the mischief. The question of the LSK representative not practicing focus and tribunals is a relevant issue. And coincidentally, maybe Lady Justice Nancy Baraza will help me on this one here. This issue arose out of consistent conduct of male representatives of the LSK to the Judicial Service Commission. The first male representative to the Judicial Service Commission, of the Law Society of Kenya to the Judicial Service Commission was Ahmed Nasir Abdullahi. The second one was Professor Tomo Jenda. Then we have the present one. Many of you will remember that the present male representative of the Law Society of Kenya to the JSC made it a manifesto issue, a campaign issue that if elected, he will not appear before judges. The fact that it became an election issue tells you that there was a practical problem to be dealt with. And it is because perceptively, and I use the word perceptively advisedly here, the first two male representatives of the Law Society of Kenya to the Judicial Service Commission were perceived to have used their elevated stature as having a role in the employment, promotion, and general HR function of magistrates fully, and having a role in the appointment and an aspect of discipline, which is the recommendation aspect of discipline of judges, to either intimidate judicial officers or get some undue influence. I remember there were actually court cases where objections were raised, particularly during the tenure of Ahmed Nasir Abdullahi, whether he could appear before courts, whether he could appear before the court. And if I may be clear here, I think there was one matter where learned colleague, senior counsel, Mr. Murgor, raised an objection, a matter he was appearing with Mr. Ahmed Nasir, as whether Ahmed Nasir could appear before the court. So there was a practical problem. I think, speaking for myself, and to create an element of level playing ground and to remove a perception of undue influence or intimidation, there is merit in the fact that representatives of the Law Society of Kenya to the Judicial Service Commission should not simultaneously appear before judges and magistrates. And I think, again, just for the benefit of our listeners, many of you will remember during the interview of the Chief Justices through which Justice Maraga was appointed Chief Justice, there was a representative of the Law Society of Kenya who kept interrogating a judge on the position the judge had taken in the matter in which the representative had appeared as an advocate. Now, the whole thing appears embarrassing because you appear to have taken a personal grievance one notch too high. So I think in that historical context, there is merit in the proposal that people who then offer themselves to sit on the Judicial Service Commission do not lose their office as advocates generally, but lose an element of that aspect, which element is actual appearance before judges and before magistrates, either so that they don't seek to gain undue advantage or to intimidate, or they do not create the impression that they are having an added advantage, an edge over the others by virtue of their offices. Does that require a constitutional amendment? I think Senator Mutula Kilonzo has mentioned it. We are in the habit of constitutionalizing everything. This is a matter that can be dealt with statutorily, and where one perceives that it impedes anyone or it stands in the way of anyone's absolute right, then it can expressly be mentioned in the statutory instrument at hand, the act that it is intended to limit that right to that extent. It can be dealt with statutorily. There is something very disturbing about perceiving every societal problem as a constitutional problem. There is something very disturbing about constitutionalizing the solution to all societal problems. Now, the question of harmonizing the terms of office of Deputy Chief Justice and Chief Justice, again, I struggle to understand the practical problem that this was intended to solve. I understand myself, the practical problem it was intended to solve. I think there is a practical significance of a law reform initiative. One, there must be a redundancy in the law that we are seeking to deal with, that there is a provision in the law that has become redundant, hence an obstacle to good order. Or there can be a lacunae or an abeyance in the law that we seek to fill. Or there could be a mischief. Somebody has taken advantage of the existing law to achieve a particular mischief and want to truncate the incident of that mischief. In that trilogy of mine, which I use to approach law reform questions, I have found it very difficult to understand what mischief this was intended to resolve, particularly because reading the report of the Building Bridges Initiative Task Force itself, I do not see the mischief set out, which then attracts this as the efficacious solution. Back to you in the studio.
All right. Thank you very much for your comments, Mr. Ongoya. Thank you very much for highlighting the challenges that we are facing, which is that we want to legislate on everything. And as such, some of these things can actually be done through policy amendment and also through a general discussion and a consensus. So yes, these are pertinent issues that we have all raised. And actually, we are looking at the chat section right now, and a lot of you have actually asked questions that we hope that our panelists will be able to interrogate and look at. The first question that we have seen is from Samuel Njenga, who asks, and I think I want to ask this question to Honorable Lady Justice Dr. Nancy Baraza, which is that by the president nominating the office holder, and that I assume is the Judiciary Ombudsman, he will then have 5 seats within the JSC that he has a hold of: the 2 non-lawyers, the PSC representative, the Attorney General, the persons who are, and also the persons who are there to represent the general public. What do you think is the impact of that, or the impetus of that on having a judiciary hold by the executive? Over to you, Honorable Nancy Baraza, for that one, as we sift through many of the comments that are coming in so that we can see which panelists will address the questions that are being posed. I think we can start with you, Lady Justice.
Thank you very much. This ombudsman thing, and I did my background research on how the ombudsman thing has entered BBI. The judiciary itself had proposals to BBI, and in those proposals was that office of ombudsman. And very, very unwittingly, the judiciary has handed itself over to the executive. Their proposal could have been misunderstood. And as Ongoya has said, these are things which could have been done administratively or by way of law reform, by omnibus provisions. I worked at law reform, and we used to get those proposals and we put them, they go through parliament. How this becomes a constitutional question is what is now landing us here. The judiciary has handed itself over very unwittingly to an executive, which is now creating a body not, I think, envisaged by the judiciary itself, and giving it powers even to sit in the JSC, meaning it is not even going to serve the purpose that an ombudsman, a judiciary ombudsman, is intended to serve. But that said, I think having an executive appointee sitting in the judiciary, in the Judicial Service Commission, is blotting the executive representation at the Judicial Service Commission. Because the executive is represented very, very ably by the Attorney General, by 2 members, my fellows of the representatives of the public. So we don't need to add more. We don't need to add more. This is going to amount to emasculation of the judiciary, but I keep feeling they were so unwitting in handing themselves over to the executive. But certainly that ombudsman should just be an administrative office on the initiative of the judiciary and have nothing to do with being an initiative of the executive and being given powers even to sit in the JSC. It cannot work. And I think the viewers are right to ask these questions. It is the way it is even formulated is incongruent. Constitutional office answering to other constitutional offices, it will not work. Enhancing executive representation at the JSC is again not good for us. For those of us who are in the struggle for the independence of the judiciary and for a new constitution generally, I think that is now taking us backwards.
Thank you.
All right, thank you.
Thank you very much, Judge. Thank you very much, Julie. Just allow me to reinforce your perspectives, Judge, with a comment from Lilian Mahiri, who on the same subject matter on the ombudsman. She says that the Judiciary Ombudsman's role in dealing with complaints against judicial officers also has the has the mandate to ensure citizens' access to justice is not impeded in any way, that the rights of citizens are protected as guaranteed in the Constitution. This office must therefore operate independently of other arms of government. So just reinforcing that there's a question of independence, but also who are they accountable to? And the mechanism of creating the office is, should it really be constitutional or should it be administrative? Allow me to also read another comment from Kwamchetsi Makoha. He comments, and I'll direct this comment to Senator Mutula. He says that the annual State of Judiciary and Administrative of Justice reports from 2012 to most recently 2019 outlined the work of the Ombudsman, outlined the work of what the Ombudsman was doing. It also listed the number of complaints received against judges and judicial officers year in, year out. He's just wondering, and this information has also included dismissal for, or suspension from duty and recommended action. So he poses the comment that the trouble is that the members of parliament do not read the report, which is transmitted to them this year. Perhaps, Senator, you want to comment about the reports that are prepared by the judiciary that contain already existing proposals contained in the BBI, and whether or not really do our parliament read some of these reports. Over to you, Senator.
Thank you. Well, Kwamchetsi Makoha is known for his articles and for satire. I thought that was just being satirical. The fact is that the reports of JSC, just like any other commission, are tabled, and the respective committees of either the National Assembly and Senate, Justice and Legal Affairs, the respective committees handle them. Now, what he doesn't know is that on the column of complaints of the Judiciary Ombudsman, what contains here is a schedule. They do schedules of 6 cases dismissed, etc., etc. So that's what so strictly speaking, they send those reports, but those reports are scheduled. You don't get to know that there was a complaint against Judge X or Judge Y or Magistrate X. That we never get to know. I want to say this and just to echo the sentiments of DCJ. The fact is, in this constitution, there is a provision for JSC to act in its own motion for removal of a judge or any other person. And I get the impression, and I could be wrong, that this amendment is not targeted at at magistrates or clerks. It's targeted at judges and Court of Appeal judges or the Supreme Court. To some level of extent, I think, now speaking as a legal practitioner, I think the idea that the judiciary started flexing muscles, and those who have been in the struggle of making the judiciary independent in terms of resources, in terms of making sure they have a fund, you know, the other day they were deducting their budgets, should be alive to the fact that this is part of it. Now, the question as to whether the Attorney General is sitting, etc., etc. Why should an Attorney General, who is an Attorney General of Kenya and legal advisor of our government, appear as if he's holding brief for the president or the executive in the JSC? I mean, it's a very strange way of thinking, and that's the point I'm making. That if I am president and I appoint Nancy Baraza to sit, and I don't want to be president, sit in the JSC, then that person is supposed to be holding my brief for purposes of JSC and not for purposes of the overall conduct of that commission, or for example, the Parliamentary Service Commission or any other commission. I remember Oluwaringo asking Oluwaringo this question. Oluwaringo was to sit in the Salaries and Review Commission as a representative of the Senate. So I asked him, why haven't you ever sat with the senators? He said, by the way, I'm not a trade unionist. I was not appointed to sit as a trade unionist for senators. So there's a point in having those numbers. But essentially to say that the executive looking for quorum, the number of people who sit, the number of people who are supposed to help in the agenda, whatever agenda executive should have in JSC is baffling. But it is important we say the reason we have this problem now is because our current JSC is easily dysfunctional because of board wars and people who sit in the commission as if they are therefore holding brief for the executive, fighting left, right, and center. That is the problem we are having. But I hope in the future, and in another dispensation, we can have members who sit in the Judicial Service Commission and exercise their role under Article 1 to represent the public and not the executive or any other interest. Thank you.
Wow, thank you very much, Senator, for that. I think that is the aspiration and the wish of all Kenyans, that every institution is impartial and they deliver their mandate without fear or favor or contradiction or influence from any party and do as they are taken their oath to do. So I think that is what we hope. Now, I want to take a comment from Francis Aywa. That is a very interesting name, Aywa. He says that it seems that we need to think about the hierarchy of administrative actions in relation to judicial conduct. Conduct that falls below the threshold of removal, which can be dealt with by the Office of the Judiciary Ombudsman, and conduct that meets the threshold of removal, for which we can rely on the already established mode of removal, i.e. JSC for officers below the rank of judges and tribunals. So he's basically saying that indeed, maybe there's an opportunity here to create a hierarchy on how to deal with these issues. Now, having said that, we have gotten a request by Mr. Kwamchetsi Makoha, who would wish to actually voice his question and pose it to one of the panelists. Kwam, do we have you on the line?
Yeah, good morning.
Right. Good morning.
Yeah, thank you. Thank you for giving me this opportunity. I thank the senator for mentioning that I write satire, but more important thing is that I was very privileged to be asked by the former Chief Justice Willie Mutunga to help in preparing the very first annual State of the Judiciary report. So these are details that are very close to my heart. And so I know a little of that detail a little more intimately than he imagines. The question then, I think, just sort of to bring the panel a little closer to the question in the room, it appears to me magistrates can already be removed. They can be dismissed, they can be suspended by the Chief Justice. The only people who actually are now, I think, in contention is the removal of judges, which I think is the bone of contention right now. But even as we are discussing this question about the removal of judges, I think we need to appreciate, and I will be guided by the very eminent panel that you have. It strikes me that this is a struggle for power. And the more judges are making significant political decisions, the more there is an evident struggle for power with the other arms of government, that is the executive and parliament. And hence the desire, I think, for parliament and the executive to insert itself into disciplinary processes. But already there's actually a functioning disciplinary process in the judiciary. Magistrates can be removed, they can be suspended. It's just that judges, taking out a judge is very difficult, and for people who have gone through a vetting process, such as DCJ Nancy Baraza and the current DCJ and others, they know that to get appointed to the position of judge is not a joke. You really have to be a person of very high standing, very high intellect and integrity. And therefore, that is why I think the removal process is that difficult as well, because appointing people to these positions is not easy. It's not a walk in the park. So I think the Constitution makes it equally hard to take them out. So the question for me, I think, is how would the panelists help us in resolving the apparent struggle for power in which the judiciary is being sacked? And I think that this struggle for power emanates from the decisions that judges are making in political disputes. Thank you.
All right, thank you very much, Kwamcheti. I think that question will be best addressed by Senator, Honorable DCJ, former DCJ. I think we will start with you two addressing that question, and then we will go to Elisha and Christine.
Can I start?
Yes, you can.
I said this before in my comments, that I personally think that the struggle for removing the independence of the judiciary, the real independence, real or perceived, of the judiciary is real. It's obvious the executive is not happy with some of the decisions that they are made against or injunctions or conservatory orders, etc., which is a good thing. But that is not answered by this, because I've said that, just like DCJ has said, in a lot of jurisdictions you have an ombudsperson, and that ombudsperson, whether a man or woman, that person handles these complaints in such a way that those complaints are then handled administratively by not lumping it on a judge, because you remember DCJ was of the view that the DCJ is not busy. I didn't know that a DCJ is not busy. So you give it to another person who is qualified as a judge to handle these matters, and then the matters go to JSC for purposes of a vote. What would be a contradiction is to have an ombudsman who has made a report against a judge which and a JSC might act upon, sitting as a member of JSC with a vote. It's ridiculous. It's like a judge of the High Court going to sit in the Court of Appeal. Just sit. You know, it doesn't make sense. And we must say that the principle is correct, the drafting is wrong. And what Kwamchesi Makoa is saying, that in terms of political decisions, it's not the first time that the courts in Kenya are having problems with political decisions. The previous courts had those problems. But even though that there were political issues that needed to be addressed, and the executive needed some way of manipulating decisions that are being made, whether it's manipulation in inverted commas or influencing, the fact is we have commercial disputes. You have commercial disputes that have not been resolved since the Ringera removal of judges. I have one instance of a gentleman who sat in my office crying, saying a judge was removed. And he showed me the report of those commissions. They found that there was integrity issues about that judge who met two senior lawyers. He went to the Supreme Court under Section 14. The Supreme Court said this Section 14 is unconstitutional. Don't think about the politics. Think about ordinary Kenyans who are losing land, who are losing property to impropriety. And they are the majority. Out of the political cases that these courts are handling, they are just one or two or three. And my good friend Elisha Ngoya is famous for so many of these cases in the Supreme Court and High Court. How many times have you had him? He is about 3 to 5. The majority of the cases are actually individual rights of Kenyans that are being impeded by impropriety, not the political cases, the cases between Senate and National Assembly. Those are small little things. And I think my view is that I'm more interested in Kenyans not losing their fundamental rights and their fundamental and property, or their rights to things, on their rights to be Kenyans, or rights to their I mean, remember the case of Miguna that we argued with Senator Orengo. Those are some of the fundamental questions that we must address. That the intention could be that they want to capitalize on it. They were unhappy, possibly because of the presidential petition. They're unhappy about some of the injunctions on some of the projects. But we must encourage the executive to understand that they need a good litigation counsels in the Attorney General to argue their cases. They are losing because they are just fundamentally just goofing. Thank you.
Thank you very much, Senator. Over to you, Honorable Lady Justice Dr. Baraza, to speak to what Kwamchetsi thinks is a way. This is an issue of power struggles. This is an issue of the executive trying to undermine the judicial independence, and is stemming from historical tough wars between the two. What are your thoughts around that?
What I want to say is these are political offices also. Even judiciary is a political institution. It's a legal institution, but a political institution. And therefore, there are all these power struggles. And considering the place from where the judiciary has evolved, I went through the entire history presentation before we put together the judiciary transformation framework. And the judiciary come from an extremely pathetic state of being a branch executive with a mere 2 lines about the judiciary, funding underfunded, and we know the problems that with that. So what I would ask Kenyans to do is be on the roads. The new constitution gave you independent and a strong judiciary, and we must guard against any attempts that would weaken the judiciary again. And this, it could be a perception, but this sloppy drafting around or conceptualization of the Judiciary Ombudsman is bringing in those fears. Regarding the role of the JSC, again, I agree with Honorable Mutula that once appointed to the JSC, I think people should exercise as much or the highest level of integrity to serve the Kenyan people. But sometimes I think we are human. You get to hear, there are all manner of things that go on there. But ideally, I think our problem is issues of integrity, issues of our values, issues of being confused as who we are answerable to. And we are answerable to the people of Kenya. So my plea would be that we cut the independence of the judiciary as much as possible, and that the executive should respect the decisions of the judiciary, that we should strengthen the institutions within the judiciary itself so that it maintains its independence. Power struggles are always there, and considering the central role that judges and the judiciary plays, you can't put it past interested parties to ensure that it is weakened. But we must guard against that and refuse any attempts that would weaken the judiciary. It matters for rule of law. It matters for our survival, for doing away with arbitrariness, and it is important that we do that.
Right, thank you very much, Judge. Christine, same question, same reaction? Let's hear.
Yes, I do agree with what Senator and Judge have said in relation to, and also Kwachesi has said. Yes, of course, there is a dysfunction we are having right now in the democracy we set up in our constitution. I think one of the panelists mentioned earlier on that we had certain ideals and values, and we put a lot of goodwill in that constitution, hoping that the entire framework will work in the way we envisioned. So we thought through the leadership and integrity provisions, we have people of integrity in the executive and in parliament. And we thought through all these, therefore, when we'll be able to have parliament come in as a proper check to executive conduct, that people in the executive and parliament are able to work on the basis of cooperative governance, society problems are negotiated at parliament, and solutions then are properly negotiated solutions are found there. But now we don't have really an effective opposition. And we have an executive that seems to be minded to re-centralize as much of the powers that were supposed to be curtailed by the 2010 constitution back to itself. So that now we have a dysfunction in all these systems that were supposed to help set up properly negotiated problems. All these problems themselves then are finding themselves at the judiciary. It seems that the judiciary is the only one who can, the only institution now that can effectively work as a check. So they are increasingly tackling political problems, which should not be the case, setting up the judiciary for more criticism, for more targeting by the other arms of government because of that. So yes, I'm not surprised by this sort of now trying to muffle and to lessen the authority of the judiciary in any of these ways, because as we've said, most of these problems that have been mentioned by the panelists, including issues with the speed of delivery of justice, all of these things that can be solved through administrative processes. It's also quite interesting for the judiciary also to be blamed for some of the things that actually are being set up by the executive for them to fail. So you are claiming judicial processes are taking too long, but still you handicap the judiciary by not giving them judges. You hold the appointments, you hold the money, so that you're handicapping them, and then now the narrative changes. So yes, since the judiciary now seems to be the only effective check against executive and parliamentary excesses, that's why we have these kind of proposals on trying to curtail their powers more. So whereas reprimand and warning of judges is not a big concern, as that has been said happens elsewhere, but the suspension clauses need to be looked at very, very carefully, because that has the real ability to cause a chilling effect in the judiciary. So yeah, so that is what I can say about that, Julie.
All right, thank you, Christine. And you've actually touched on a comment that was in the chat section from Caroline Kasoa, who said that what can be done to promote enforcement of court orders and the rule of law because of the lack of swearing in of the 40 judges. One of them passed on, unfortunately. So 40 judges now, because this is an underlying issue that is actually resulting into the various things that you're seeing: delayed justice, case backlog, because there is an insufficiency of judicial officers to do the work that Kenyans want them to do. So yes, you have actually even addressed one of the questions from the chat section. I want to turn to Mr. Elisha Ongoya. You've heard Kwamcheti's comments on the development of the report and how it is tabled before Parliament, and whether whether the members of Parliament have an opportunity to interrogate the report, its findings, and how then are we then creating a separate process, yet there is already a process that is reporting to Parliament, as well as the question around executive overreach, and this being a tough war between two entities. Over to you, Ongoya, for your comments on that.
Thank you so much. The struggle between or among the various powers of the state is not a new phenomenon. It's perhaps as old as the state itself, because the state is a very political enterprise, whichever way you look at it. And therefore, there is a context in which Komchetsi is right, and there's also a context in which my learned senior colleague, Mutula Kilonzo Jr. is right. Komchetsi is right in the following. Let me start with Mutula Kilonzo Jr. He's right in the following, that in fact, a bulk of the work that the judiciary does is non-political. A bulk of the work. If you walk to the average magistrate's court, a bulk of the cases the magistrate's courts handle are mere traffic cases where people come in, and the concern of the people who come to the traffic court is not the political establishment, is how it can become more efficient in processing them, because processing a traffic case in this country takes too long, which is why a lot of consumers of that justice prefer bribing the policeman to going through the justice process. So that becomes the bulk of the concern. And therefore, once you look at it from that perspective, Mutula Kilonzo Jr. is right, that you need to solve a bulk of the people in Kitui, in Machakos, in Kasipul Kabondo, just want their succession cases to move faster. They just want their land disputes resolved slightly faster. The commercial empires in this country, the banks and so forth, just want, cases involving their exercise of power of sale to move faster, so that their ability to realize their security is not impaired by injunctions that then last for 5 years without the matter ever being, finally determined. So Mutula Kilonzo Jr. is right in that. But the reason why the powers that be in the other organs of the state target the judiciary is not because of that. It's not because of how they handle the multiple land cases in this country. It's not because of how they handle the multiple succession cases in this country. It's not because of how they handle the multiple traffic cases in this country. It's because of that one single political case. Call it, the Miguna case or the presidential election dispute. That single case has ripple effect that pushes political establishments to ask, how do we tame this institution from being wrong? So to that extent, then Komchetsi Makoha is right. There is a sense in which the political establishment's attraction to the judiciary, and I know there's a way in which power plays out that's very strange. Somebody could even be looking at a future scenario and saying, how do we control this Supreme Court ahead of the next presidential election that is 2 years down the line? And that's all. In their lifetime, they may visit a lifetime of adverse consequences to the judiciary just to control one historical episode, the next presidential election. That is all. So we must understand the way in which power plays in that context. And I in my reflection on this issue, anytime I look at a multiple disorder in our systems, I see very organized disorder. The disorder itself may look so simple and easy to resolve, but it exists as a deliberate maneuver by wielders of power, by influential characters, for purposes of a very selfish end, which may just be a one-off lifetime episode, as I've said to this. Looking at the question of discipline of judges, because Komchetsi has talked about removal, as I look at it, and as a way of just informing this debate further, is that I'm a skeptic of thinking that you will resolve the judicial problem by just continually removing erring officers. I think there is a better way to deal with this. And if my listeners were to buy my hypothesis is an attempt to make those erring people better people. If we focus our energy in making them better people, then I think we'll have a more sustainable institution than continually removing them. And I say this, some of those people, for example, exhibit incompetence. And we must ask which incompetence is so bad as to warrant removal, and which incompetence can be remedied by retraining. Because our constitution, for example, provides for continuous judicial education. To what extent can we just make some of them better by better training? Which of those wrongs can be remedied by self-correction, by listening to them and by giving them a chance to correct themselves better? I'll not name names, but I'll tell you this, I'm an advocate. There are people I knew in this judiciary who struck me as being fairly bad. They were fairly bad people. Their mannerisms, their language, the way they dealt with consumers of justice was so bad. Then after the vetting process, some of them were temporarily removed and returned after the review processes, or maybe after judicial intervention. As I observe some of them, they have become fairly improved versions of themselves. And I think that's a better way to go about it. When you give another chance, they invariably become better people. And that if we had a way of reforming the judiciary by making those who serve there better people, it's a more sustainable way. But that actual removal must be reserved for very bad and very incorrigible cases of persons in the judiciary. That way, I think we shall get a more functional, a much better judiciary. I want to remind our listeners that in 1803, following the famous decision of the US Supreme Court in Barbary versus Madison, Chief Justice Marshall presiding, President Madison declared then that, you know what, Marshall has made his order, let him enforce it himself. So as our listener, Madam Hasoa, raises the concern, what do we do about this consistent refusal to enforce court orders? Let us not give up hope. It's a continuous experiment. Developing a democracy can be very frustrating sometimes. I have come to appreciate that we need to know we shall chip at injustices slowly and incrementally. Fortunately for me, those who invest their life in the quest for justice eventually become victors, however long it takes, which is why I advocate for the old adage that the price to pay for justice is eternal vigilance. And those are my thoughts.
Thank you. Thank you very much, Mr. Ongoya. Thank you very much to all our panelists for your insights and views. Thank you for engaging with the participants. And we have actually noted that a lot of the questions haven't been answered. So honorable panelists, if you have a minute, you can check in the comment section, address some of the questions that you would wish to look at because they are still very pertinent. I have also noted the concern that Ms. Christine has also raised as regards what are we doing as various entities to push for the funding of various commissions which are now toothless, not because they do not have the will and the drive, but because they do not have the financial resources. So what is happening in regards to the implementation and the operationalization of the Judiciary Fund? What is happening around most of these commissions being adequately resourced to do their functions? So yes, we can see those questions and thank you for bringing them in. We will be looking at them even as we continue to wind down and conclude this very interactive session. So to our panelists, as we now close this conversation, as we come to a close, I would like you to leave us with your parting shot, your 1 minute parting shot. We will begin with Christine Konge, then Honorable Mutula, Honorable Lady Justice Baraza, and conclude with Mr. Elisha Ongoya. In your parting shot, please address the question, did the BBI adequately address the challenges that are plaguing the judiciary? I think that's the overarching issue, and that's the one thing that all Kenyans want to know. Did this BBI actually solve the question, the challenges that are facing the judiciary? So we'll begin with Christine, your 1 minute parting shot. You can make it 2.
Thank you, Julie. As we actually, as KI, we actually did an assessment of the 2010 Constitution when this BBI process started to try and get a more evidence-based understanding of whether constitutional amendments were needed. And by and large, whereas certain issues were identified, including in the judiciary, our finding was that those things could be cured by first fully implementing the constitution we currently have, because that is not fully implemented. We don't really know how the framework is actually meant to work because it's not been fully implemented. And then for those other issues, large or otherwise, can be solved through policy or legislative measures or even practice directions. And again, so if I look currently at the major problems that our judiciary is contending with right now, are cuts in their funding, issues to do with appointments, issues to do with infrastructure, issues to do with impunity that is brought about by disobedience of court orders. I do not see anything in the BBI that actually solves those big problems. There's nothing that is talking about ensuring that all arms of government, even though you disagree with that ruling, that you actually abide with that ruling, because now it becomes part of our laws. just actually giving enough money to this arm of government, this branch of government, to be able to carry out its extensive mandates. That has also not come across from the BBI. One of the issues that came up when COVID started was actually in past budgets, they actually totally removed the line for ICT. So now COVID came in and all of a sudden we saw the big potential risk that came from that kind of meddling in the funding of the judiciary. So yes, those are the big problems as I see them, and those are not problems that the BBI addresses. So it seems, as Ongoya has suggested, to be trying to solve instant or small or political problems and short-sighted ones, but giving us problems that will now plague us for generations. So that's my parting shot.
Thank you very much, Christine. Over to you, Honorable Senator. What are your parting shots? What is your parting shot from this conversation? And thank you so much for being such a lively participant. We have noted from the chat section that people are really thanking you for being as candid as you are and putting across the position that the principle was correct, but the drafting was wrong. So what are your parting shots from this conversation?
Let me say this. One, that those who believe in constitutional practice and constitutionalism generally, and I'm not a teacher like my good friend Alicia, and those who have studied either the British practice, American practice, will be alive to the fact that you cannot change this country in just one document. And the impression created, which is wrong, and the political players are to blame for it, that you will solve all the historical injustices and all the issues about where we all came from as Kushas and Bantus in the BBI is also wrong. And we must, just like every other country that has tried to resolve all their problems in their countries, make this a continuous conversation and a continued exercise. We must be prepared to try and fail. The people who agree that we must do devolution and the people who opposed it since 1963 didn't know that we could have self-governance at those levels. So and the people who, like me, did the research on having a Supreme Court, having a judiciary fund, we cannot afford to give up. I don't agree with Alicia Ongoya that once a judge is found to have committed an error, we give him a slap on the wrist and tell him, like a young child, don't eat sweets or sugar. Next time, don't touch. No, I don't agree with that, because if you are entrusted with the lives of people, you can't afford to play games with people. But lastly, let me say this. I got this book and I want to show it. It's called The Written Constitution, the British Written Constitution, this one. I bought this book because I found it very interesting that whilst Britain doesn't have a written constitution, somebody can write a book about the British Constitution and practices and usages that have become law, that have built in the hearts and minds of British. And it's not exactly a perfect society. Just like Alicia Ongoya said, we are all through a journey in pursuit of excellence. And Christianity is still being preached 2,000 years after Jesus left, and we are still trying to convert people every Sunday. This is a continuous exercise. The country must put our values in our hearts. We can't write everything. I mean, they have rewritten Article 10 in the BBI, and somebody was suggesting that, one member who I sat with was suggesting that we must make it mandatory for children to take care of their parents. Can you imagine putting that in the Constitution? If you have to remind people that they should take care of their old parents, then what sort of children are we bringing up? So I'm looking forward to a country and people like my pupil master, Dr. Nancy Baraza, Alicia Ongoya, teacher, please, can we continue preaching ideals, good practices? When you're appointed a judge, do the right thing. If you're appointed a member of parliament, just do the right thing. If you don't want and you want to do business and you're in government, go open a shop and call it whatever it is, do business. And then you won't get into the sort of problems that we have in this country. But to imagine that we'll wake up and we'll draft another constitution and another constitution and another constitution, and it will change this country. It will not happen. This country, people are still pre-2010. People are saying implement 2010, and they are living in pre-2010. when we had the constitution where Moi was around. So we love to choose our struggles, but we must continually ask, and the people who are in our profession, and a lot of us and seniors like Nancy Baraza, we must continue telling even the people who are coming after us that this is a noble profession. Once we get into it, we must do what is right. That's all. Thank you.
All right, thank you very much, Senator. Leave the ideals and do what is right. All right, now we will hear parting shots from Honorable Lady Justice Nancy Baraza. Please give us your parting shots from this very lively discussion.
Thank you very much. I think we gave Kenyans a very good and robust constitution, which remains largely unimplemented. So when you talk about BBI going to create equality, through what? We have all those values in the constitution. Look at Article 27, look at Article 10, look at that document. What do you want to change? If you implement, then we wouldn't be finding ourselves running around in rings like that. When we appoint people to positions, to commissions, please, the word integrity, our values. Don't go and do monkey things in JSC, don't do them in another commission, because that is not what was envisaged. And if we do that, by the way, this constitution can take us far. Now, coming back to the judiciary, I think BBI has completely evaded the very important question that problem that the constitution, the judiciary faces. That is the problem of funding. And from their submissions, in which they unwittingly handed themselves over to BBI with the ombudsman, they also had requested for a 3.5% of GDP allocated to judiciary and charged directly from the consolidated fund. And that actually would fulfill the requirements of financial independence for the judiciary. Now that one, they never touched it, they don't talk about it, and yet that is at the heart of a functional judiciary. That they can enmesh as in some administrative office of an ombudsman and forget what really can make a judiciary more efficient, functional. It actually puzzles me. For me, they would have served the country and the judiciary better if they addressed the question of independence, the financial independence of the judiciary. They did not. They don't talk about, now that they decided to talk about everything, why don't they talk about their disrespect of judiciary judgments? That is sending bad vibes to ordinary Kenyans, and that will lead us to anarchy. They don't talk about it. So I think I would agree with what the other speakers have said, that they have eschewed central problems, just like they went around, I think, governance issue. If you do not address the historical land question in this country, we shall keep having these problems. But those are things they eschew, they run away from, and take us around in circles. But for the judiciary, I think we are enmeshed in arguments which should never have arisen in the first place. Thank you very much.
Thank you very much, Lady Justice. I think you have hit the nail on the head when you say they excused the pertinent issues that are ailing the judiciary. Now we will turn to Mr. Elisha Ongoya for your parting shot from this very interesting, lively, and engaging discussion that we have had. What is your parting shot for today?
Allow me to give my parting shot in the nature of a response to two interlocutors. One is Anna Kavele and two is Luciana Thuo, my very good colleague. Anna Kavele seeks to know whether, in my view, the BBI is a clawback on certain institutions. And I think the answer to that question lies partly in what Senator Mutula Kilonzo Jr. and Justice Nancy Baraza have alluded to. That, and I've said this before, that there is nothing that we are going to deliver, practically speaking, through the BBI process, even assuming it were to pass, that cannot be delivered under the current constitutional arrangement if we meant business to deliver anything to the people of Kenya. Luciana Tuo inquires whether the current administrative structure of the Judicial Service Commission can make the discipline of judicial officers transparent and inspire public confidence in the judiciary. There are two challenges here. I think it's important for Kenyans to know that since the establishment of the Judicial Service Commission as an institution, the actual administrative structures, just getting the clerk there in the office and the sweeper there and the finance officer, those people who make institutions function, has never been completed. Why? There's no funding. And that's a basic problem. You don't need any constitutional amendment to make that be. Sometimes we even complain about how long it takes to just process a complaint against a judicial officer. But if you don't staff the office with proper, registrars, clerical staff who process just basic files and place them before the commission for processing, it can make the structure extremely inefficient. The problem is that elementary. How do we solve this? And I think the answer largely lies in what Mutula Kilonzo Jr. alluded to. Let's just learn to be good people. Let's just ask, what are the attributes of good men and women?
All right, we are trying to get Mr. Elisha Ngoya back so that he can give us his parting shot. So the technical team is dealing with that, but we have gotten him back.
Sorry, I may not know where you lost me, but I'll proceed from where I had reached by just posing the question that the challenge as I perceive it myself is just for us individually and collectively to commit to do the right thing when we are given responsibility. The number of people who take positions of responsibility to be positions for private benefit in this country are just too overwhelming. And if those people just learned to use their office for the right purpose, a bulk of what we perceive as problems in this country will disappear without any further institutional and legal reforms. And I think if our energy focused there, doing the right things in the right spaces, we will get this country to the correct path towards progress and development. And those are my thoughts.
All right. Thank you very much to all our panelists. Thank you very much for the time. I now wish to call upon my co-moderator, Ms. Elsie Saina, to give the closing and vote of thanks from this meeting. Thank you very much.
Thank you very much, Julie. That was an interesting session. The question and answer, further interrogation, thoughts from our panelists. Thank you very much, Ms. Christine Konge. Thank you very much, Honorable Mutula Kilonzo Jr. Thank you very much, Dr. Nancy Baraza. And thank you very much, Elisha. And as jurists, you rightly put it, let us use our officers to do the right thing. Just do the right thing is the common thread that is emerging. Besides our problems, we write the proposed solutions that have divergent views. How do we then move ahead? Let's just do the right thing in whatever level of responsibility or sphere of influence. And as a Commission of Jurists, we also acknowledge that the judiciary indeed should be accountable and transparent, in the manner in which it underscores and delivers the will and sovereign will of the people. We, however, emphasize that the need to ensure the principle of separation of powers as espoused in the Bangalore Principles of Judicial Conduct and the Latimer House Guidelines, which underscore that judicial independence is indeed a central tenet of advancing the rule of law. Each arm of government must exercise, therefore, its responsibility and restraint in the exercise of power within their constitutional mandate and sphere, so that they do not infringe on the legitimate power vested on other arms of government. The interactions of the three arms of government should be based on the principle of cooperation, complementing, and ensuring that they, as our panelists have clearly put it, just the people that sit in those offices should just do the right thing. In conclusion, as we close this webinar today, as a Commission of Jurists, We are open and will continue to have a constructive dialogue on the proposed amendments that have been included in the BBI report, where we intend to share our best practices, interrogate the challenges, look at the lessons learned, and come up with solutions, hopefully that should stand the test of time, and indeed look forward to a time when we will not necessarily need proposals around who should be in the judiciary or who should be in the Judiciary Ombudsman. We, as Elisha says, we look forward to a place where we can all just ensure that the offices and the institutions are working coherently and complementing each other's mandate. Allow me to take this opportunity to thank our able panelists again, who have brought in their experiences, practical experiences, and their time and knowledge to share with our members of the public and our fellow members. You've guided the deliberations, and we truly appreciate that. We understand that you are very busy, but thank you for taking the time to join us today at ICJ Kenya. Also, thank you very much, our team here at ICJ Kenya. I'll begin with our council, ICJ Kenya Council. Thank you very much for spearheading this conversation, and for also my colleagues and the technical team behind the scenes working very hard to put this webinar to tireless efforts and making sure that this webinar is a success. I thank you very much from the ICJ Kenya house here. Allow me to also thank my co-moderator, Julie Maveka. Wonderful moderating sessions and interrogating sessions. And we both wish you all a very great afternoon. God bless you. God bless Kenya. Have a good afternoon. It's a bye from us.